So I do find that it's relevant to basically respond to you all talking about how upset Mr. Baldwin was, and certainly that you considered that fact of consequence, and I'm deciding that this rebuttal information is of consequence. I also find that its probative value is not substantially outweighed by the danger of unfair prejudice and all the other choices that are under 11403. I will say that I think that I'm not going to let everything in. I'm going to focus on page 4, and I'll start with line 16 and on page 4, and I will go to page 5.
And I'm sorry, is this what's coming in or what's staying out?
No, it's coming in. The rest of the yellow is staying out.
This issue goes directly to Mr. Baldwin's state of mind, and I'm looking, Your Honor, I'm sorry, at basically 12 through 14. He understands that whether there's a live round on set or not, these guns can be dangerous, and he says it right here between 12 and 14. What he's talking about with the wadding can come out. If you're closer, you can get a burn. That's him talking about his knowledge of the danger of these guns. That goes directly to the heart of the state's case. As the court knows, the state doesn't disagree with 15 through 17. And again, when we start here on 18, where Mr. Baldwin says, "I'm told," that again goes directly to his knowledge of the injuries that can occur if these guns are not handled with safety. He says right there, "I'm told even with the flash powder you can cause contusions and you can do a brain bleed and die." And you know what? We can take out this part here that says which both of them died, because that is relevant to the Brandon Lee, John Eric Hexum that we agreed to remove. So I don't oppose taking out both of them died, but this goes directly to the heart of the state's case.
You know, we did not ask witnesses questions regarding this type of harm and what was learned, and certainly those kinds of things might have been able to come through Ms. Popple. And so, you know, and again, we did not do jury selection on this, which we absolutely would have. We didn't open on this because of the ruling and the way that we understood it based on our review of the transcript. So I do have concerns that this is going to prejudice the defense, and we would ask that the court consider not allowing
Attention
this.
to my ruling, because my ruling was with respect to witnesses, because I particularly told Ms. Morrissey that her witness got to ask her witness one sentence. And that is because Mr. Carpenter was really opinionated about that blanks can kill in the grand jury, and I did not want to move away from the fact that they weren't blanks, it was live ammunition. But this goes to Mr. Baldwin's state of mind, completely different, and I'm going to let this in as well. Page 15, 1 through 4, lines 1 through 4. I'm going to make a ruling. These were given to, your intended redactions were given 2 days before. And so far, the only thing I've heard that was a surprise was the testimony of his knowledge of guns. So let's see. Well, I mean, everybody got a point somewhere. I don't find that, I'm going to redact that. I don't find that's relevant. It's just in passing, really. And he's talking about other people.
Mr. Baldwin's motivation to lie about pulling the trigger of the gun. I'm 63 years old with 6 kids. I can't rely on luck anymore. He's talking about his career and that he can't rely on luck anymore. This goes exactly to his motivation not to tell the truth. Sorry.
Can we approach briefly?
Sure.